People, the question they're asking is, will Deputy Chief Minister of the former Deputy Chief Minister of Delhi, Manish Sisodia, get a bail in liquor policy case? But before we make up our mind, let's see what the judge had to say, and let me read out what the observation or the obiter dicta, as it is said, of the judge. And those are very, very important. Till the proceeds of the crime come, PMLA doesn't come. That's one. Where is the evidence except for Arora's statement? That's two. Did you see Nair and Sisodia discuss bribes? That's three. How will Sisodia come under Money Laundering Act? That's four. So these are the four points. And on this debate, I'll be joined by Deshwatan Nigam, advocate and political analyst, Akhil Khan, political analyst, and my input editor, Brijesh Pandey. So before I play out the bite, let me ask Brijesh. Brijesh, what do we make of the obiter dictas of the judge?
Well, I think, Justice Khanna made very scathing observations based on the evidence which was produced on him. If I may read the kind of strong observations he said, because there was talk about how bureaucrats made a different presentation under the political pressure and all. There was a particular line which was devoted to it. And then, he went on to say that, that there are apparent factual inaccuracy in the documents which have been produced. He went on to say that, whatever they're doing, there is no concrete evidence against Manish Sisodia. He even went on to say that Dinesh Arora, who is the businessman and who was turned approver of the enforcement directorate in the Delhi excise scam, he said that all you have is his statement against Manish Sisodia, and you very well know that this statement will fall flat in 2 minutes of cross-examination. So those were very hard-hitting statements, which have been oral statements, of course, which have been made. I think the case is on the next Thursday. But the observations of Justice Khanna has really made this.
Today, observation was the story. Obviously, we are not talking about judgment. Mr. Nigam also joins us. A very warm welcome to you, Mr. Nigam. What do you make of these scathing remarks of Justice Khanna? Do you think that they'll have impact on the final outcome of this bail hearing, sir?
No. Kartikeji, there will be no, effect on the final outcome, because that will go through trial. And the trial court will see. And if any new evidence comes up in the meantime, then the supplementary charge sheet can also be filed. And supplementary evidence can also be filed in the court of law. Those processes are open to the prosecuting agency. But certain observations which have been made clearly shows that the certain people in certain agency are not doing their job seriously. Because if you remember, in the case of Manish Sisodia, the issue came up why Aam Aadmi Party was not made a party. If you're saying that the Aam Aadmi Party got the money, the illegal money, under the Prevention of Money Laundering Act, that has not been explained, which clearly means as a layman also, if somebody has got illegal money, that person, a juristic and legal person, which the Aam Aadmi Party being a registered party has not been made a party. Clearly a flaw on the part of the investigative agency. Secondly, also, another observation, because Supreme Court's observation have to be taken in totality, because they have said, where is the, you have included attempt, section 2 attempt, because punishment for attempt and actual crime is one and the same thing. So that you have not included attempt also. So these are observations, obiter dicta, obviously they are not part of the order as it was going on. And thirdly, they have been trying individually, whereas there is a conspiracy, a group of leaders of the Aam Aadmi Party have worked together. Where is that charge? So individually you are trying, but the conspiracy angle has also to be coming up. Members of the cabinet or the MPs or the leaders of the house are coming up in this. They have not been working in isolation, but a conspiracy. I'm not saying whether they are guilty or not, but these are the charges that should have been brought out. Individually as well as collectively, they have to be liable. And that aspect has also been ignored, which clearly means somebody somewhere is not doing the job seriously. Hawala transactions, as the Supreme Court also said, are
Mr.
difficult
Nigam,
to prove.
coming to this issue, I would really like, for journalists, if you say what are obita dicta, it's like reading the tea leaves, it's like getting the wind off it, that's where the fun of covering the courts is all about, because ultimately the order is shared by, is shared by everyone, because it's something which is documented. But there are two things, if you can just really take us through. One, when he's talking about the PMLA case, that's our last graphic. Can you please explain it to our viewers? What does Justice Khanna mean in context of the proceeds of the crime?
See, proceeds of the crime, there has to be a separate crime, which we call cognate, crime, which out of which if you have made money, which is a black money, then what an accused does is to try to convert that money into white money. And that property needs to be recovered and the money needs to be recovered. So that is the proceeds of the crime. And crime is separate. Under PMLA, there has to be a cognate crime. Although in some judgments, also in some high courts, they have said PMLA is an independent act, and therefore you don't need a separate crime for that. It's a crime in itself, PMLA. However, there are different judgments out here, but Supreme Court is quite clear on this. So therefore, that proceeds of crime, which is the black money, illegally gotten wealth, which you are trying to convert it into a white money. And that needs to be recovered. But however, if you recall, PMLA is an act where you are guilty till proven innocent. If the charges of attempts are brought in, and if it is proven that attempt has been made, whether the money, because in Hawala transactions, no records are found. The cash transactions takes place from outside into India and India to outside. So somebody from the Hawala transaction, if come forward as a witness, good enough. But otherwise, if an attempt is also established, then it becomes very clear, it will be very difficult for the leaders who have been brought into this net PMLA, will be very difficult for them, because attempt is also a crime under PMLA, apart from, actual thing. So these are very important aspects which need to be gone into, and the court's observation in Supreme Court has to be taken in totality. Not you can't take one sentence out and then, cover it. Therefore, it is very important when they talk of attempt, when they talk of Aam Aadmi Party, when they concede that the Hawala transactions are difficult to prove because there is no money trail as such. However, the agencies are saying they have got certain, in the case of Sanjay Singh, that they have certain digital evidences also which they have recovered from Sanjay Singh's residence. Therefore, you have to treat them as a group also, that a group was conspiring to cause that revenue loss and take money, 100 crore money or whatever the amount has been there, which they are talking about. That aspect also has to be seen. If you do it in isolation, then only attempts will hold. If you bring in conspiracy, then probably most of the people will fall in the net.
Okay. Now, before I play out the bite of Arvind Kejriwal, let me read out a figure to you. Quote unquote judge, you have taken two figures, 100 crore and 30 crore. Who paid them this? There can be so many people paying money not necessarily connected to liquor. Where is the proof? Dinesh Arora himself is the recipient. Where is the evidence? Except for the statement of Dinesh Arora, is there any other evidence? Justice Khanna asked. The chain has not been fully established, the bench observed. The court said the money has to flow from liquor lobby to the person conceded that establishing the chain is difficult as everyone was done undercover. But that's where your competence comes in. As Mr. Nigam was talking about the competence part, that's where your competence comes in. Justice Khanna said, referring to the Enforcement Directorate and Central Bureau of Investigation, referring specifically to the flow of money in charges against the AAP leader filed by ED under the Prevention of Money Laundering Act, Justice Khanna asked, Manish Sisodia is not involved in all this. Vijay Nair, which is another accused, is there, but Manish Sisodia is not in this part. How will you bring him under the Money Laundering Act? These are the questions which I'll take to Mr. Nigam and my colleague Brijesh Pandey. But let me play out, because there's politics also playing out with this entire case, which is legal. Let's play out the bite of Arvind Kejriwal.
सारे केस झूठे लगा रहे हैं ये लोग, तो कुछ इतने केस लगा लिए, इतनी जांच कर ली, कुछ निकलता तो है नहीं. तो इस जांच के खेल में टाइम ही खराब होता है, सबका टाइम खराब होता है, जांच एजेंसियों का भी टाइम खराब होता है, सरकार का भी. सबको काम करना चाहिए, देश के लिए काम करना चाहिए, तभी तो देश तरक्की करेगा. सबको झूठे केसों में फंसा के उससे तो देश तरक्की नहीं करेगा. जिस तरह के सवाल सुप्रीम कोर्ट आज पूछ रहा था क्योंकि मामला सब्जुडिस है, मेरे को कोई टिप्पणी उस पर नहीं करनी चाहिए, लेकिन जिस तरह के सवाल कर रहा था उससे तो मतलब एक तरह से एक फीलिंग आ रही थी कि गलत ही केस बना रखा है इन लोगों ने हमारे ऊपर।
संजय जी कुछ कहेंगे अपने संजय जी कुछ कहेंगे? संजय जी कुछ कहेंगे? है मोदी जी का, हारेंगे मोदी जी चुनाव हार रहे हैं इसलिए संजय जी आप
You know, Brijesh, apart from the political banter, Modi hiring and all that, I think the cases have politically also sent a signal to the entire opposition. You know, today, if you look at Tamil Nadu, the raids
an
that
IT raid.
yeah, the raids that have taken place, and the fact that we say that, you know, bail is a norm, it's not an exception, and then the Sanjay getting picked up. Do you see that, you know, as the elections close in, things are heating up?
Well, of course, yes. And I think there is some merit in what the opposition party says, because, you know, if you take into the last year's, you know, the statement which was placed on the House of the, in Parliament, you know, it was a clear indication, and there was also reports, investigations done by Indian Express, which clearly pointed out that when it came to, you know, ED raiding on opposition parties, and when it comes to ED raiding on people who are, you know, either part of the NDA coalition or others, there was a massive difference. And it clearly do point out to the fact that, you know, that how come a majority of the raids are only specific to the opposition leaders or the states which are governed by their rivals, rather than in states which are ruled by BJP or their allies.
Okay, I'll quote another para from Justice Khanna's Obita Dicta. The money is not going to him. In case it is a company with whom he is involved, then we have vicarious liability. Otherwise, the prosecution falters. Money laundering is entirely a different offence, the judge said, pointing out, according to the agency, the case is not one of attempt but actual involvement. Justice Khanna remarked, what is the activity connected with the proceeds of crime? This is not generation. PMLA deals with process of activity connected with the proceeds of crime. So till the proceeds of crime come, the PMLA case doesn't come. You referred in a passing way, job not well done, but I think it's a case which is lingering so much. How can you have this sort of an affidavit in the Supreme Court, or this sort of a conversation with a bench in the court, sir?
Is it to me?
Yes, Mr. Nigam, and then I'll go to Mr. Akil Khan.
So the fact remains that what Supreme Court has said has to be looked into seriously by the Enforcement Directorate. And the fact is, the proceeds of crime may not be able to be recovered as it happens in Hawala transaction. Because the reason being, Hawala transactions do not leave a trail, those are indirect evidences. And that has to be taken into consideration. In this particular case, in the case of Sanjay Singh, because all these cases are related, there is a witness which says that I have given this money to such and such person. So this is how you see the attendant circumstances, corroborative evidences. If you don't have the actual trail, then the question comes whether PMLA would apply or not. Then another question that you have raised, very important, is bail is a norm. Bail is a norm under the Indian Penal Code. But this, under the PMLA, it is not a norm, which has been very clearly given in this particular act itself, where a person is guilty till proven innocent. In the IPC, a person is innocent till proven guilty. Correct. So the onus lies here on the accused to prove himself that he is not guilty. So onus is very difficult out here for the person. And certainly, while giving bail, it will be seen whether this person will again commit an offense or not. These are various conditions which are there under the PMLA. So this act is absolutely different. Here, bail is an exception, not a norm.